Sandin vs. Connor, 1995. Chief Justice Rehnquist delivered the opinion of the court. We granted cert to re-examine the circumstances under which state prison regulations afford inmates a liberty interest protected by the Due Process Clause. DeMott Connor was convicted of numerous state crimes, including murder, kidnapping, robbery, and burglary, for which he is currently serving an indeterminate sentence of 30 years to life in a Hawaii prison. He was confined in the Halawa Correctional Facility, a maximum security prison in central Oahu. In August of 1987, a prisoner officer escorted him from his cell to the module program area. The officer subjected Connor to a strip search complete with an inspection of the rectal area. Connor retorted with angry and foul language directed at the officer. 11 days later, he received notice that he had been charged with disciplinary infractions. The notice charged Connor with high misconduct for using physical interference to impair a correctional function, and low moderate misconduct for using abusive or obscene language and for harassing employees. Connor appeared before an adjustment committee on August 28, 1987. The committee refused Connor's request to present witnesses at the hearing, stating that witnesses were unavailable due to move sick to the medium facility and being short-staffed on the modules. At the conclusion of proceedings, the committee determined that Connor was guilty of the alleged misconduct. It sentenced him to 30 days disciplinary segregation in a special holding unit. The Court of Appeals for the Ninth Circuit reversed the judgment. It concluded that Connor had a liberty interest in remaining free from disciplinary segregation, and that there was a disputed question of fact with respect to whether Connor received all of the due process under the pronouncement Wolf v. McDonald. The Court of Appeals based its conclusion on a prison regulation that instructs the committee to find guilt when a charge of misconduct is supported by substantial evidence. The court reviewed a shift from cases looking at the importance of an interest for the prisoner to those considering the content of the prison regulations, and stated no longer did inmates need to rely on a showing that they had suffered a grievous loss of liberty retained even after sentenced to terms of imprisonment. For the court had ceased to examine the nature of the interest with respect to interests allegedly created by the state. In a series of cases since Hewitt, the court had wrestled with the language of intricate, often rather routine prison guidelines to determine whether mandatory language and substantive predicates created an enforceable expectation that the state would produce a particular outcome with respect to the prisoner's conditions of confinement. By shifting the focus of the liberty interest inquiry to one based on the language of a particular regulation and not the nature of the deprivation, the court encouraged prisoners to comb regulations in search of mandatory language on which to base entitlements to various state-conferred privileges. Such a conclusion may be entirely sensible in the ordinary task of construing a statute defining rights and remedies available to the general public. It is a good deal less sensible in the case of prison regulation primarily designed to guide correctional officials in the administration of a prison. Not only are such regulations not designed to confer rights on inmates, but the result of the negative implication jurisprudence is not to require the prison officials to follow the negative implication drawn from the regulation, but is instead to attach procedural protections that may be of quite a different nature. Hewitt has produced at least two undesirable effects. First, it creates disincentives for states to codify prison management procedures in the interest of uniform treatment. Prison administrators need to be concerned with the safety of the staff and inmate population, ensuring that welfare often leads prison administrators to curb the discretion of staff on the front line who daily encounter prisoners hostile to the authoritarian structure of the prison environment. Such guidelines are not set forth solely to benefit the prisoner. They also aspire to instruct subordinate employees how to exercise discretion vested by the state and the warden, and to confine the authority of prison personnel in order to avoid widely different treatment of similar incidents. The approach embraced by Hewitt discourages this desirable development. States may avoid creation of liberty interest by having scarcely any regulations or by conferring standardless discretion on correctional personnel. Second, the Hewitt approach has led to the involvement of federal courts in the day-to-day management of prisons, often squandering judicial resources with little offsetting benefit to anyone. In so doing, it has run counter to the view expressed in several of our cases that federal courts ought to afford appropriate deference and flexibility to state officials trying to manage a volatile environment. Such flexibility is especially warranted in the fine-tuning of the ordinary incidents of prison life, a common subject of prisoner claims since Hewitt, claiming liberty interest in right to participate in shock program, a type of boot camp for inmates. Siegel versus Biller, unpublished, claiming liberty interest in the waiver of travel limit imposed on prison furloughs. And this is just a bunch of cases that they're citing. Bergen versus Nix, claiming liberty interest in receiving a tray lunch rather than a sack lunch. Spurrett versus Walters, finding liberty interest in receiving a paperback dictionary due to a rule that states prisoner may receive any book which does not present a threat to the order or security of the institution. In light of the above discussion, we believe that the search for a negative implication from mandatory language in prisoner regulations has strayed from the real concerns undergirding liberty and protected by the Due Process Clause. The time has come to return to the due process principles we believe we correctly established and applied in Wolf v. Meacham. This case, though conceded putative, does not present a dramatic departure from the basic conditions of Connor's indeterminate sentence. Connor's confinement did not exceed similar but totally discretionary confinement in either duration or degree of restriction. Indeed, the conditions at Halawa involved significant amounts of lockdown time, even for inmates in the general population, based on a comparison between inmates inside and outside disciplinary segregations and state actions in placing him there for 30 days did not work a major disruption in the environment.